Uh,
That's live now, Richard. Jesus Christ.
Now we're live.
Shout out to the guy on William's show that said, when are you guys coming back? I enjoy listening to you guys talk about nothing. Well, I let Richard twist my arm, and here we are.
I like the name Toe Cramp, though.
Toe Cramp.
That's good.
Toe Cramp appears to only be the only one in the show right now.
They're actually, because I see the numbers. I see the total numbers.
Oh, do you? I don't see
By
that.
the way, this is the total numbers in the universe that are watching us, by the way. So it's nothing to be like happy about. But right now we're in the universe.
Let me guess.
In the universe, how many beings, because I don't even know if these are humans, how many beings are currently watching us in the universe?
I'm going to say 21.
30, 33.
33.
34. 35. I'll call him out. I'll tell you in a couple of minutes to see how he goes.
Let me just make a qualifying statement here. Those of you that have tuned in, if you thought the last shows were prepared and organized, those shows were put together in maybe 30 minutes. This one was put together in maybe 30 seconds.
No, it took longer than that. We'll see how it goes. But I figured we'd talk about a bunch of stuff. But before we get started, what I really wanted to do was talk. This is like directed at Elon Musk. How's that? I'm going to go right for it. Elon.
Right for the judge.
Elon. Between you and I, you and I are close. I know. I actually, I'm closer to you than you to me. I believe that's the way I would look at it. But what we really need, since you're on Doge and that Department of Governmental Efficiency, and I don't want you to have to listen to this whole stupid live stream. What I need you to do is, amongst the things you need to do, is get rid of immunity. I'm going to repeat this. Get rid of immunity. In other words, like all these agencies that you're going to be, I guess, clearing out and thinning out. Another thing you need to do is get rid of immunity so that all citizens of the United States, even JR, I think he qualifies sometimes as a citizen of the United States, that everybody who gets screwed by whoever has a chance to get a remedy. Because otherwise it's not fair. And that seemed would be consistent, I think, because I know you're for transparency, and this whole idea is transparency. So to the extent that you can make this as a secondary goal amongst many secondary goals, I really think that removing immunity should be one of them. And if you need to speak to somebody about that in detail, JR is available. He's available. If he's not available, call me up or call up Farzad. Farzad, I know who Farzad is. Call Farzad or contact Farzad. But I'd love to discuss that with you or JR. And again, I think it would really help kind of solve a lot of problems that shareholders, especially small shareholders, have in dealing in the marketplace. So I mean that seriously. So I'm throwing that out now. Secondarily, since we're on the topic, so the lawsuit involving Elon Musk pay package is now final. The pay package was thrown out by the Delaware court, and the court awarded $345 million in legal fees to the plaintiff's counsel. The case, in large part was attorney's fees. The counsel for plaintiff was seeking at one point in time $5.6 billion in legal fees. They got 345, which is obviously a huge amount. That was just final. It came final. They have 30 days to appeal, probably a year, 18 months to get a resolution in the appellate court in Delaware. And then depending on how that goes, and I think there's constitutional issues, by the way, in that case with regard to the statutes are pretty loosey-goosey. What's a benefit to a company, and then the issue about the attorney's fees There was a bunch of
See,
process.
I have a real issue with that because let's just say you take an average. Let's just say this is a top of the line law firm, right? So let's say they're charging $750 an hour, and they were demanding attorney's fees of $5 billion. That comes out to 6,666,666 hours worth of work.
I think they did like 20,000.
That's ridiculous.
But that's what they did. But if they had just used that, whatever the number is, whatever the actual hours was, because I looked at it, if they just did it times like a rate, it would come out at like $13 million. If you gave it like a multiple,
that's what they should be paid if that's what their rate, and that equals the amount of hours that they worked.
Part of the issue was, and this is Elon Musk and some shareholder derivative suit, which means it's not for the benefit of the shareholders, it's for the benefit of the company. The plaintiff in that case had 9 shares. So he had exactly 9 more shares than George Washington has, to be honest. But sorry about that. But it was, like some guy had no financial interest, had no financial interest. I think he had been a lead plaintiff before. And
who, George Washington or this guy?
Maybe George Washington too. I don't know. But he had been a lead plaintiff before, so maybe he got 10 grand out of it or something out on top, because they could pay you something like that. But it's really for the legal fees and to undo the pay package for like 5 minutes, because they re-voted on the pay package. They approved it. When they presented that to the judge, and again, this is in this case, it may have been the correct procedural decision, but the judge ignored the second ratification. That's what got the end result, which is about 30 days ago. The amount of the legal fees, she had no idea. She being the judge, really had no idea how to calculate. It's kind of an interesting issue. How do you calculate legal fees? So to get legal fees, you have to show there's a benefit to the company. So there's a benefit because there's like a governance benefit. In other words, if you operated improperly and I pointed it out to you, then there's a benefit. We've clarified that, and maybe somebody else in the future won't do it. And then, okay, that's kind of the idea. But alternatively, there can be a financial benefit, and that's the way they want to attach to a financial benefit if you're the attorneys, because then you could say you're entitled to a portion of that. So they claim that the shares that Elon got, the value, if exercised, was going to be on the order of like $56 billion. But you can't get a windfall as a attorney's fee award. And the judge said if we give you like a percentage of that, it's going to be a crazy number. So we can't do that. So the judge was couldn't figure it out. Threw out the hours times the rate, threw out kind of the reasonable value of the services, ended up taking some accountant's formula that gave a value of the options at 2.5 billion, took 12% or 15% of that, and that's the attorney's fee award. That's the calculation. Purely like, besides the fact whether you like him or not, freedom of contract and, should shareholders be allowed to do what they want? It's not like everybody was in the dark. Everybody knew what was going on. So I'm kind of like, in that case, I'm kind of go with the shareholders. But beyond that, like the calculation of attorney's fees seem like BS to me. And I think that's an issue that's going to go up, and because that's a huge amount of attorney's fees. So that's ongoing, probably take a year and a half to get resolved, and then maybe to the Supreme Court, which would be really interesting. Before we start, of course,
I'm still stuck on George Washington shares.
Okay. Did you know?
No, I didn't. I know where this is going. Go ahead, get them out.
No. Here we go. I was listening to a commercial yesterday. It was it was for California psychics, and they were seeking out employees, and they were trying to set up interviews. And I thought to myself, why does the psychic hotline actually have to have interviews of anybody? I mean, wouldn't they know that kind of without the interview? That was my thought. Do you know what city smells the most like fish?
No. Oh, fucking Christ. No. Which city smells the most like fish? You can't even say it.
Altoona.
That's like an hour and a half north of me.
Oh, is it really?
Yeah. It's not even close to a fucking body of water.
Last, because I can't read the other one. Last but not least, I just saw this great bumper sticker as I was driving to my office. It said, "Honk if you like peace and quiet." I thought that was pretty funny. All right. So we did like Elon. We made the plea to Elon, and then we did the I talked about the big lawsuit that's still pending about his pay package, which, by the way, it appears, if you follow Tesla stock, it appeared like it didn't really slow the stock down because since the presidential election, Tesla stock is up between 70 and 80%. It's a pretty short period of time. So interesting that has gone on. Somebody put up something on. I was just going to throw this out. Somebody put on something on Twitter or X, whatever. Do you think X is caught on, or it's still Twitter to everybody?
I still call it Twitter.
Yeah, it's funny because how long has it been?
Try to call it X. It doesn't sound right. It's like,
I know. How long has it been? How long has it been?
Year and a half, maybe. I don't know.
I don't know if there's ever been something that's called that his name is something, but it's called by something else.
Kleenex.
Yeah, its name is X, but again, it doesn't it doesn't ring true.
Yeah. Well, yeah. Well, first off, what do you call a post? You still call it a tweet.
Yeah, you call it the same thing. And they haven't been able to kind of like flip it. They haven't figured out something.
I think he would have been better off. Okay, change the name, but still call them tweets, or use the bird logo somehow integrated into the X logo. I don't
maybe so. Yeah. Okay. Sounds wonderful. It's a great idea. I'll give you credit for that one.
Thank you.
TikTok. Did you see? Last week, or I think it was last week or last one, we talked about a trial court had enjoined TikTok. Said basically, unless you sell, I think it was a Utah court. Unless you sell to a American owner, you're out. You can't operate in the United States anymore. Took it up to the Court of Appeal. They sought an injunction, denied.
Really?
They think the Supreme Court won't take it. So TikTok probably. And it's going to be probably a First Amendment issue to the Supreme Court. It impacts their, First Amendment rights theoretically. So it'll be a free speech issue and a bunch of other crap, I presume, in my constitutional analysis. But I think
does George Washington have a TikTok?
He does have
Does George Washington have a TikTok account?
He does. He has wooden teeth, I still think, by the way. His teeth are still intact, as a matter of fact. But it's interesting because they're going to have to find the owner pretty quick. I think they have till January, like middle of January sometime. I'm sure they can get an extension, if need be. But they probably have to show that there really is an owner. What's interesting about this is one of the donors to Trump, a big donor, I think, and a friend. He was a big investor in ByteDance. I think that's the company that actually owns TikTok at this point. And he was pushing back This is a few months ago. He was pushing back about TikTok having to leave unless they were sold. And this court ruling, these rulings now are kind of against that gentleman's position, which might displease the upcoming president. And so interesting to me. I don't know if I don't know if the president, I really don't know. I don't know if the president has juice with the Supreme Court. I don't know if like the president, and I mean this for real. I don't know if the president could call up like Chief Justice Roberts and, off the cuff, or like be dropped off at the Supreme Court, go in the back room. And I don't know if he could make a suggestion. I don't know if that happens. Would it happen like a third person or somebody else might, have an interaction with somebody else? That I believe happens. But because it's a close friend of the president, it would be interesting to see if he would intercede. If he doesn't, and that guy loses his interest and has to get out, it's a big deal. It's also a big deal to Facebook, Meta. See, that one worked, right? Because eventually, how do you refer to it? You refer to it as Facebook or Meta?
I mean, I don't even have the app on anymore, but I still call it Facebook.
Oh, you call it Facebook. Okay.
Yeah.
I call it Meta. So that one I've been able to kind of turn over. But it's interesting how that, like the name, it's good to have a name with a lot of impact, but then it's hard to change that name.
Oh yeah, for sure.
Yeah. But anyway, so Meta would be the biggest beneficiary, I think, at this point in time, because they would be in direct competition. I don't know how their stock is done, but that would be interesting. Of course, this is not legal advice, not financial advice. This is like, if you can't tell, this is not really super serious.
Fucking utter nonsense.
Yeah. Hopefully there's something in here that's actually either truthful or helpful, in some combination.
I thought we agreed we weren't going to be helpful tonight.
Well, I mean, inadvertently we might be helpful. I try to be accurate. By the way, we're at 198, just to give you an idea. But I thought it was interesting just because the company's going to have to do something at some, and I didn't know if that was going to happen because of the interesting issue. Oh, what I was going to say about Twitter, there was a point. Twitter and X. So I see it sometimes. I don't know if like it's goofball stuff or whatever. Talking about GTII. Yeah. So have I been active in GTII? Unfortunately, yes, way too active in various ways. But I saw, and I'm trying to help out, obviously, and I had my own fun time in court and whatever. But I saw somebody post something about, and I think I can't tell if they're goofing around or I can't tell if they're being silly or being malicious. Can't tell. I don't respond, but I'm gonna respond now, just as a general statement. So GTII is a company is trying to be repaired, let's say, currently. So I saw on Twitter somebody saying basically that some company, and then cited my Twitter X name, made some representation about GTII. So I said, I posted, and this is what I say, I don't endorse, nor am I involved in the selection of any company that is going to be acquired, do business, whatever. I wish sometimes, but unfortunately, nobody has offered to bribe me or offered to give me any money. Unpopular, like there was a bunch of short reports that came out. Do you remember those? There were like some reports that had busy listed and like 50,000 people. And JR and I would do like a live stream the night before, talking specifically about those guys, and we wouldn't get listed. And it was kind of offensive that they didn't proceed against us. So here's another case of that. So
you know, I popped on William's show. I told you this. I popped on William's show because he was getting questions on GTI. I was really struggling, and so I was making some comments, and he was like, "Hey, get on here and help me out." So I popped on, and one of the comments, somebody said, thank you guys for working with GTII and doing everything you're doing for the shareholders. And I mean, you and I have never worked for GTII. In fact,
No.
you were taking the charge on GTII. I got pulled into the legal issue last summer and then just kind of threw it your way and removed
Yeah, you know
myself.
what? It's honestly, and again, I don't mean this like to pat ourselves
Right.
in the back. It's more to avoid. And I'm gonna be honest. It may sound like we're being like, wow, you're spending all your time and it's free, but it's also, if you start taking money, then you have certain obligations that arise out of there. And
Mhm.
listen, I'm on the same team because I'm a shareholder. So how if this doesn't go well, then I do as well as everybody else.
Right.
But
Well, I don't
we're
even think it was about working with the company. I think for you, just I'm kind of refreshing my memory on that time period. You smelled something wrong. You just
Oh
did.
yeah, I mean it's legit. Again, you don't in life. Unfortunately, you don't always do things for the right reasons. But this one, I was in it. It smelled bad, and it turned out seemingly it turned out to be kind of it smelled bad, and it was like it smelled. So
I think
so,
it was
but the
it
point,
smelled bad, but was ultimately ended up worse.
yeah, and it's involved, and I think there'll be a report early January. That's my understanding, and I'm basically what we're trying to do is to keep the company and everybody who's affiliated with the company. That means the lawyers, the receiver, whatever, honest. That's it. So we want to know what's going on, and again, that's what I do. So I ask questions. Sometimes I get good answers, sometimes I don't, and I understand either way because there's reasons for both. But we're not involved. We're not management. We're not ownership. We don't endorse, and we're not going to endorse. We're absolutely not. So, to the extent you ever see some posting or some representation to that effect, and we haven't said it, then it's not true. So, just kind of leave it that way. And sometimes people might. That's why I also prefaced it by saying it could be a joke, like somebody thinks it's funny, or it could be, which is that's why I don't want to I'm not going to go after somebody or whatever because they just may think it's funny and whatever. But if they're trying to be malicious, confuse people, whatever, that's when I think it's a
Right.
different issue. And I don't know who's posting whatever. And again, I'm not the one who's going to make those decisions. If to the extent, and I believe, although I'm not certain, but there have been people or I believe there have been suitors in some respect, but the company is not in a position to do anything until everything is done. I think we'll know a lot more about the audit by the time of the next report. I think I heard, not certain, but I think I heard that there were subpoenas that were issued. Haven't seen any.
GTI.
Yeah, GTII. So that could be like to banks, that could be to trustees, but it sounds like if you were going to do work in trying to enforce the rights of the company, issuing subpoenas. I mean, bless you,
Excuse me.
bless you.
Sorry about
We've been involved in matters, right? That if we could have a subpoena be honored, it'd be great. One of the things we're going to talk about is one of the things we talked about before we started is we can't get discovery sometimes. And here, if they're going to go after documents, whatever, that's what you should do. So that's it for GTII. I expect we'll have a report soon. I may know some information this week. I don't know. I'm going to try to meet with
So
somebody.
let's take a step back. I think let's not confuse people. So why, if there's no pending litigation, can the receiver issue subpoenas in a GTI
there
case?
is there is pending litigation.
Oh, there
So
is
there's
pending.
Yeah,
Oh,
there's that. Yeah. So
oh,
yeah. There's a
got it.
Nevada lawsuit that's ongoing
So
against
that's where the
various.
subpoenas are coming from.
Yeah, there's a Nevada lawsuit going against the various officers and directors, and the receiver was appointed in that lawsuit. And per his power, the subpoenas. And again, I haven't seen them, so I don't know if this 100% sure, but I feel comfortable that there must be something like this going on, more than just a guess. By the way,
Oh yeah.
yes, and I think it's multiple, not like one or two. I think it's multiple. And I remember that we went through the report. I think we've gone through the first two reports. We literally did a live stream, and we literally just kind of read through the reports. And I believe in the second report, there were a couple sources of money that were not insignificant. I mean, there was like $1.5 million somewhere or whatever. So it wasn't insignificant money. So I presume that that's what's being investigated. As far as I know. Anyway, did you want to add anything to that, sir?
No, just I'll reiterate what I said on William's show, and that is that the nice thing about what's happening now is you're going to get periodic updates from the receiver. The next one, and I didn't know this when I was on William's show, but obviously you're saying the next one is going to be sometime in January. So sometime in January, we can all expect an update from the receiver on what's going on. So
Yeah, and I know, like I threw out one point in time when, well, I'm not going to say it. I guesstimated with somebody when this all would be done, but I don't feel comfortable more that it's just pure speculation. So like, I think we should just go as we go. So like,
right.
my understanding is January is a report, and then we, just like the last report was more detailed than the first report, the next one should show some kind of progress that was discussed in the second report. So that's kind of what's going on. The receiver is out trying to get money, trying to finish the audit, trying to get it trading. I get that question a lot. When's this going to happen? I have no idea. All I can tell you is what I know, and that's what I'm telling you. So hopefully soon. That's funny. Going recreational tonight. That's very funny.
Because your hat's backwards.
Oh, I see. Is that what that means?
That's what I took it as.
Oh, okay. I like it.
Maybe not unless there was a deeper meaning there that
I didn't know. I didn't know. I didn't know if that was the
Mark
term
V.
of
What
art.
are you talking about?
I didn't know. I didn't know it. Yeah, I didn't know if that was a term of art. Anyway, anything else you want to reference about that?
On GTI, no,
GTI.
Look, patience is key right now. Patience is key.
And I know, by the way, everybody's like, pissed because listen. Everybody here knows that it's one of those cases you've been sitting, you lost your money, you're sitting, there's nothing you can do about it. Sucks. Yeah. Yes, I agree. But we're headed in the right direction. Hopefully it will resolve favorably for all of us. I'm in the same boat. JR is in the same boat. So, that's the way it goes. All right. So that's GTII. And again, you'll have a report in next month, with depending on when it's done, next month, perhaps sooner, because I may have more information this coming week. Something that caught my attention, so that's GTII. Alpine, nothing new that I know other than that they're going to, if they haven't started, they probably are going to restart the expedited expulsion proceeding. So just to bring everybody up to speed, Alpine's the prime broker for GTII. They were in the process of getting kicked out. There's a bunch of legal proceedings, and some people may even be using some of the authorities that are referenced in some of these legal proceedings, but I don't know for that for sure. But Alpine was involved in legal proceedings, and they prevailed in an appeal that basically said that before they could get kicked out, the SEC has to review the final decision. But it only applied to an expedited expulsion proceeding, which was what these morons at Finra, the SEC, were doing, as opposed to kicking these guys out. Right, JR, have I gone through the story of Alpine enough that there's no excuse for Mr. Gensler? I think, by the way, I believe this is going to be my belief from this point and forward that the reason why Gensler is resigning is because of my efforts, because of his inaction. Do I think that necessarily the next guys are going to do a better job? That I don't know. What do you think about that, by the way?
I think it's going to be. I'm curious to see what the next administration's approach is with Finra, given kind of some of and the SEC in general, given some of the negative cases they've had against them. I mean, they got lambasted this summer, in 2024. So, it's rare that. Well, I'll go back to something we learned in law school. I remember this like it was yesterday because I look back on some of the things that have happened, and it's so true. One of the things one of my professors told us was, the law goes through these significant shifts about every 5 to 10 years. And my first experience with it was same-sex marriage. That was a huge topic back in the early 2000s. And, you saw this shift in the law favoring same-sex marriages.
I didn't realize you were married to a man.
Not. I don't even want to go down that path.
Is that KNOT or NOT?
Dude, I'm at my mom's.
Okay.
Marriage, really? The next experience I had with it was the Affordable Care Act. Prior to the Affordable Care Act, health insurance plans could pretty much cover and not cover what they wanted to. And then boom, 2010, the Affordable Care Act was passed, and now insurance plans were mandated to cover all of these things. And now you're seeing kind of this shift with agencies and the bureaucracy where, Chevron, I mean, people don't understand, when it comes to agencies, how big Chevron case was, and now the Chevron case is gone. That's a huge shift in how agencies are now going to promulgate rules and make decisions. So you're starting to see this shift in the administrative agency law, and what is that going to look like? What's that going to look like over the next 4 years? Because the administration has already been pretty out about the bloated bureaucracy that we have. So they're not going to be defending some of these agencies like you might have seen over the last 4 years, or over the Obama 8 years, the Bush 8 years, the Clinton 8 years. You're not going to see the Solicitor General defending some of these agency decisions like they had been in the past.
Here's my concern. I know, me included, I FINRA is useless, but the rules allowing FINRA to be useless are bad, just like the immunity that we started on this. The SEC is useless, useless for our purpose. I'm talking about retail shareholders in particular. So I think that things have to change, but I don't think getting rid of everything is good.
No.
So I think, unfortunately, getting rid of regulation and agencies is fine, but you have to be able to regulate. These guys can't do it at this point in time. This is not like you can reduce the size of the SEC or get rid of FINRA and it's going to improve our plight. It won't. I mean, there has to be a substantial change in how the securities markets are monitored and enforced. And that could be technological. I assume this is technological. It doesn't have to be like manpower, but it's got to be in place, because if you just remove the enforcement people, whatever, you end up, I know the end game. Everybody's going to do great until something happens and there'll be some disaster that's going to happen. I have one in mind already, by the way, that I think is potentially problematic. not now, but down the road. But I think if you don't have the right regulation, it sucks for us.
Well, Curtis and I were going to talk about this at Pulte's event, but the atmosphere didn't lend itself to kind of what we initially wanted to say. So we pulled an audible walking up to the stage and just went in an entirely different direction. But there's two primary.
Could you explain what you're referring to?
Last week at Pulte's event down
What
in
is that?
Florida, Curtis went down to Bill Pulte's retail investor event. It was primarily Bed Bath & Beyond and GameStop people, but we spoke about MMTLP. And, one of the things that we wanted to emphasize was two things: accountability and transparency. So, you can't get rid of the agencies, can't get rid of the SEC and Finra and expect to have transparency and accountability. It has to be built in to their mandates. The SEC has some level of transparency when it comes to SEC decisions, but not FINRA. We've talked about this. FINRA is subject to FOIA, and so you only get the information that they want to release. And we know, based on the fines, that they're constantly fining people for a lack of, marking things correctly, not reporting things correctly, and the fines are nominal. So until you have some level of real enforcement and real punishment, those things aren't going to change. The other thing that's always pissed me off about these enforcement actions is, they never tell you which companies these organizations are manipulating. And there's a reason why they don't do that, because if they did, they know full well that retail investors would pile into those stocks and push these guys to the brink of bankruptcy.
Well, there's a dual reason. Go ahead. Well, no, I think of it differently. I have a different reason. If I'm Goldman Sachs and I get called out, because it's happened, right? I've seen it. I'm just using Goldman Sachs as one, but it's probably anybody. So they get fined $150 million for improper trading practices, whatever, between 1997 and 2007. That's the end of the story. It doesn't tell you what the securities are. So if you happen to have owned the stock, a stock that was improperly traded during that time period, you have no way of knowing.
There's no recourse.
There's nothing.
Well, as an investor, you have no legal recourse against Goldman Sachs.
Zero.
Because you don't know. And
maybe in some states you could, like in New York has that pre-litigation discovery. So maybe if you were in New York, maybe you could file a petition to get a disclosure to see if you qualify. Maybe, I don't know.
They'd fight it tooth and nail.
Yeah, they would.
But again, remember, there's a heightened pleading requirement for securities fraud claims.
Like it's this tall. I think.
Yeah, like this tall instead of this tall.
Yeah.
So you can't even see it. That's how fucking tall
I can't see it. It's out of the screen.
So not only not only do you have to overcome this heightened pleading requirement, but you don't even know what company was involved in that. So it's there really is no legal remedy.
There's none.
When bad actors act.
I agree. I think, especially if it's the government, it's in my mind, it is a taking. You'll see that, by the way. It is a taking under the Fifth Amendment of the Constitution. Because if like the government takes something, and I know in this case, are you wondering who is it? Is it FINRA? Because FINRA is not the government theoretically, right? They're not a government agency, even though they're playing one, for tonight's performance. But they're certainly an agent of, an arm of the government. And if the government takes something from you, they're supposed to give you money. And that wasn't that funny. Boy, you have no sympathy for retail shareholders.
You're really struggling describing it. That's all.
Oh, okay. Why don't you describe it?
I mean, look, they're a self-regulatory organization that was enacted under the Securities and Exchange Act. You're not. I tend to take a more practical approach when I think about the structure and function of FINRA. I mean, it had the authority to legislate SROs. SROs have been deemed constitutional by the Supreme Court. So, eliminating an SRO, unless it's through a legislative act, it's next to impossible. Finding FINRA unconstitutional is a huge hurdle to climb, because you've got 70, 80, 90 years of case law basically saying they are constitutional, or basically saying the model is constitutional. I've always taken this approach that the only way to truly get rid of FINRA is through Congress, through some type of legislation.
Well,
That's not to say that you can't change the way they function through the courts, but getting the Supreme Court to say that FINRA is an unconstitutional body is next to impossible.
I think that, and again, that's not my goal, and I haven't seen this argument raised. Really, it's my argument. It's not my argument, obviously, but it's my argument. My argument is the immunity part. So I'm okay if the court said, it really is not fair if you're an SRO and you're not a government, but you're also you're kind of completely immune. So at least, at a minimum, you should be subject to discovery. At a minimum, maybe if there's no lot, because there might be an intermediate step. Maybe there's one is you're liable, or two, maybe there's discovery rights that don't exist now. But as of now, there's no right. So I tend to think that this court, who last term started to strip away power from regulators, might logically be able to exclude that immunity, to let them continue to operate same function, let them get insurance, and let them be exposed to their acts like everybody else who's a private company. You could say something.
I was just going to say that I've always taken the approach that you have to, model what Dr. Martin Luther King and Thurgood Marshall did, which was to chip away until you have this massive conglomerate of case law that's against them. So that by the time it goes to the Supreme Court, they have no other decision than to, strip them of their immunity, or hold them accountable, or require transparency. That's how I've always thought about it.
Yeah, the way I see it is they have a pretty substantial majority, and they may, and I would understand if they decided that, but they might see it as an opportune time to take whatever action they could, and they can. They basically decide at this point in time, as of today, any case that the conservative side of the court wants to decide, they can decide. So I don't think they have those reservations. I understand what you were saying. You think that that's the kind of the history of the court and the decorum of the court. I just don't think it's the same. I think it's, at this point in time, they have a big advantage, the conservative side of the court. And if they get issues that they could justify within their kind of whatever their mindset is, they'll go for it.
Oh, I agree. But I wouldn't anticipate a sweeping change in how they are approaching the SRO model. I wouldn't envision that.
I'm saying my solution is that immunity issue, because if you get rid of immunity, then if you had a dispute with the SEC and FINRA was involved, you could get discovery through FINRA, and it would probably resolve, from a retail shareholder's point of view, it would probably resolve 95% of cases. If everybody knew you could get discovery through FINRA, it would because they're going to be involved in every aspect of these transactions. They're going to have documentation. They're going to have it. So in my way is, if you remove that immunity, then you can keep them around. I don't care. Then they have to be good actors also at that point in time. That's the difference. So that's my mind, and that doesn't get rid of the model of having an SRO. It just changes that one aspect that maybe, in my mind, again, I don't think that should be constitutional, that immunity part of that
Well,
under the scenario.
I think what relieving the immunity part does is it really requires them to implement the law according to the law, not according to the way they see it. I mean, they're behind the iron curtain right now, and you can't touch them. By removing the immunity, by the very nature of not having immunity, people tend to act the way they're supposed to act and do what they're supposed to do. I mean, right now, these guys do what they want. Doesn't matter. They have this carte blanche, you can't touch me. And
I see.
so
Yeah, I'm sorry.
getting by that is a huge hurdle.
I see somebody posting, I can't pronounce the name, talking about the whistleblower from OpenAI. So there was, I saw it too. There's in San Francisco, I think, who was found dead. I don't know what the circumstances are. And so
Yeah,
it seemed,
I don't know either.
yeah, I don't know, I saw it too. So I don't know the circumstances, whatever. Could a whistleblower be knocked off? Yeah. I mean, could they? Of course. Does it happen? I don't know. If like a whistleblower dies, is that always publicized then? And so it looks like it happens more frequently. You know what I mean? I don't know. I do not know. But I saw it too. It makes me suspicious. I saw Aaron Brockovich or whatever, those movies, and somebody they tried to take the car off the road or something. I would guess it has to happen. You got to think of it this way: when there's billions of dollars involved or somebody's freedom from jail, will people do that kind of stuff? There'll be some that'll do that stuff. Unfortunately, I think that's the way of the world. It's unfortunate. So interesting point. So that I saw that up there. So I wanted to talk a little about something that I brought up. That I saw an article last week about a Finra arbitration. Yeah, this is last week. It was a 3-person arbitration. So Finra does arbitrations. We were just talking about the SEC and Finra. One of the aspects of Finra is they do their discipline of all their broker members, but they also handle other things, like the broker dispute I just had involving MMTLP that ended up in a Finra arbitration. So, and it was terrible, by the way. My opinion, sucked. It really did suck. It was absurd.
How did you feel about it?
Yeah. The arbiter, I thought, did a terrible job. And I thought the administrators of Finra who did the arbitration did a terrible job. And they didn't charge for any of that crap, which was part of the problem. So in other words, if you gave a lot of work, the person who was reviewing all that stuff wasn't getting paid. And it makes you wonder how much, interest they might have in doing the work at that point in time, because they didn't do very much. But what I saw last week was Finra arbitration, three arbiter panel. They gave a judgment against some member for some kind of misconduct, and they did it without doing a final trial. So what happened was they had a bunch of discovery that was outstanding. The other party didn't show up to the hearing on the motion to compel, and didn't show up at another hearing, and the panel awarded the other side the victory, and some like $100,000 in legal fees or something like that on top of that, without there ever being a final trial. So I talked about the JR beforehand, which I thought's interesting. I don't understand why you would do that, to be honest. That seems like a little bit rash. Usually you would sanction somebody so you wouldn't just enter the judgment typically this is what happened. You have to go to court. And if you went to court, the judge might not let the other side participate, but you'd still have to put on your case. It's not hard to win when you have nobody on the other side, but you got to do it. And maybe things would come out during that presentation that might change what you could get. But in this case, they didn't do even they didn't even do that. They just said they skipped it and threw him out. So what I said to JR, the irony is, in this case, the arbiters ruled against the other party because he didn't show up at the motion to compel hearing. And in my case, where I asked probably like 15 times for hearings, I never got a single hearing. So I thought that was ironic, the difference in the way the arbitration was done. And I guess that's a problem. I guess, in process, you shouldn't have, and we're not talking about the outcome, but in process, probably shouldn't have things that are done diametrically opposed to each other. Like in one case where you allow discovery, in one case you don't allow discovery. That's probably not a good practice, right?
I mean, look, we've talked about this 1,000 times. It's the Wild West. The rules are completely different. You're not entitled to 3/4, not even a percent of what you're entitled to in federal court, and that's another hurdle to get over with Finra is the mandatory arbitration clause.
Yeah. And that's a tough one.
And the other thing too is
what's got to happen, I think, with that for the arbitration clauses, I think that's got to be congressional legislation. I think they just got to they just got to say that you can't have this type of clause.
Yeah, it's just a hurdle you're not going to get over in court. I mean,
no, not as is. Not as is. It's going to have to be restricted. It's going to have to be restricted at a legislative point.
And look, you and I talked about this at length 2 years ago. I'm sure we even talked about it on the live stream. Even if you find some level of fraud or misrepresentation of fact or something in the terms of service, you have to go back to the controlling state law for the terms of service. Every one of them has one that's conflict of law.
And they all are oppressive and one-sided. And
but here's the point I was trying to make. When you go and review, say for example, Fidelity's conflict of law provision is Massachusetts. So when you review Massachusetts state law, their contract law is pretty straightforward. Just because you found the contract, the essence of the contract void does not terminate the arbitration provision. You've got to have a compelling public policy reason for a court to void the arbitration provision. And most state law that deals with contract failures, contract breaches, they just don't allow it.
Yeah, that's why that's why I suggested a federal law that limited those kind of provisions this point forward. Really, to me, is the solution. Not because, again, like at this point in time, it's so ingrained in the court system. There's such a presumption in favor of it.
Right.
Really tough to get by it. So it really needs federal legislation.
You have to make the Judge Cardozo magic argument for why those things are null and void in a court. Otherwise, it's just not happening.
Yeah, it's again the fastest way. And maybe this will happen now. Maybe that'll be the change in this particular administration. Maybe there'll be legislation that gets passed to deal with that. So,
right. I got 5 minutes. My daughter's texting me. So
okay. I was going to talk about, did you see that there's a Supreme Court case that's up in front about the interpretation of environmental laws? So there was an argument last week. The question is, in making a decision, do they always have to look at the impacts, both past and present? Past. So if you're here, do you have to look upstream, downstream impacts? Because if you have to look at that, it makes it harder if you want to do a project and it's subject to that, and you got to prove it doesn't impact upstream, downstream. That is a much bigger hurdle for a developer, for example. So apparently in this case, and I don't remember what the issue was, but it's ultimately that whether they have to consider upstream and downstream. Conservative court suggested probably don't. So that there may be a ruling coming down probably sometime in 2025 that makes it you don't have to consider environmental concerns as much. That would be the kind of the bottom line, and that would make development and ultimately would make development easier for probably all kinds of projects. Maybe a lot of oil and gas, I would guess, probably also might ease the way for that. I did notice, by the way, there's a lot of interest in crypto. I follow MicroStrategies. It's some crazy stock. It's a stock that basically buys Bitcoin, and it tries to buy Bitcoin. This is where I mentioned that eventually we may have a problem. This is the kind of thing that when I hear about, I think it has a problem. They issue bonds. The bonds are at zero interest. They're due, let's say, in 5 years. In 5 years, they're convertible, but the strike price is like 50% above what the current price is. So the stock has to appreciate. If it doesn't appreciate in that 5 years, you get back your initial principal. But it's basically an interest-free loan at that point in time for 5 years, which is a good deal if you can get it.
Right.
And they make those bonds. They get the bonds. They take the money and they buy Bitcoin. And they kind of put off the due date. In the meantime, there's a 3-year put option, which means if you're the bond holder, you put up the money, and it's a 5-year bond. In 3 years, if it meets certain conditions, you can call it and get your initial base money out. And as a result of that strategy, he's collected, Michael Saylor is the guy at MicroStrategies. He's collected somewhere on the order of about 450,000 Bitcoin, which makes him one of the largest Bitcoin holders. If you multiply that out, it's about $45 billion, which is a nice chunk of change to have in your pocketbook. It's a software company. So I was involved with that. I got involved with it. I bought it. Most of the times this doesn't work. So I preface whatever I say. I bought it at 130. I got out at like 450. So it was good. And it was fast because it ran really fast. So now I'm playing a little bit with a leveraged version of that right now. And it just got put in the NASDAQ 100 MicroStrategy on Friday, but at 5 o'clock. So on Monday, we'll see what happens. So I'm playing the little leverage version of that. I'm playing like IBIT. Do you know what that is?
No, I'm sorry. I was reading a question.
All right. IBIT's Bitcoin, BlackRock, Bitcoin, Bitcoin, a bunch of Bitcoin related. So the question is how long to stay in, and if they will act like they have acted in prior cycles. So it will be interesting to see how it goes. Capiche?
Yeah. Sorry.
Yeah.
I was reading a question. So all about the money asked a question about says, I have a question. Why is William Ferron saying that GTI has a dead stock when a year and a half ago, him and Ace, or a year and a half ago, him, Ace, and him was saying GTI was eminent for a super squeeze? I can't answer that. I mean, I doubt Richard can either. You know, that's more of a question for William.
Yeah.
I was on the show the other day helping him talk about the receivers report. So and all about the money. We're not ignoring your questions. It's just hard to see them on the screen. Richard can't see them, so I have to be looking for them, and I wasn't looking. So yeah, please don't think we're ignoring your question. So
yeah, and
sorry.
people might think, by the way, and people might think certain things and might be wrong. It happens. It doesn't always have to be like as I don't speak for anybody else. So I'm not saying what somebody did, but sometimes people just misspeak or speak in error. It's not always intentional. So I don't know. So I try to give people the benefit of the doubt if I can. Listen, it's unfortunate for everybody that GTI has sucked. And it has sucked, by the way. It has sucked.
Sure. Dude.
But at least over 2024, we all knew, basically from the whole year, we all knew it sucked. We've all been on that same, nothing's been surprise anymore. It all kind of came out during the year. So, yeah. And listen, I will certainly, and JR, if not me, when the day comes, if the day comes, I'm hoping the day comes, that we got to the point it's trading again and we can go back and, and it's talking about all those amazing acquisitions or targets.
Well, I'm not laughing. Yeah. I mean, look, you got to stay positive. That's all. I mean, we're all in the same boat.
Yeah.
All shareholders. I own shares. Richard owns shares.
Yeah.
Just patience right now is the key. So I do have to get going. My daughter's texting.
All right. Very well. Then let's call it call it here. Thanks for everybody for being here today. If you have any questions about anything, please let us know. Have a great weekend. Have a great Sunday. Be well, and we'll see you soon.